I'd like to welcome back a guest who's been here before, expert on law and constitutional law, Jared Goldstein, Roger Williams University Professor of Law. Thank you for joining us again today.
Well, thank you for having me.
It's been all SCOTUS for the last 24, 48 hours. We knew the president was going to announce his nomination last night, and it was kind of getting down to the wire there, but Brett Kavanaugh eked it out. Did you expect this?
Well, you know, he had been talked as a potential nominee for quite a while. I think it was actually scripted. You know, we think that he eked it out at the end, but it was like a reality show. This is what we expect from our president these days. You know, he has the primetime address. What I expected was he'd have the finalists there, and it'd be like the end of the Bachelor. Instead of handing them a rose, he'd hand them the robe. You know, and the others would cry, and you know, but we didn't have that. Instead, it was Kavanaugh. You know, who was very predictable conservative choice. He has a lot of Republican experience. He worked for President Bush. He worked for Ken Starr during the Whitewater and Monica Lewinsky investigation before being nominated to the D.C. Court of Appeals by President Bush.
So let's talk a little bit about this pick. I mean, you talk about his bona fides to be selected, but let's talk now about moving forward. Of course, we've seen a lot of backlash from the Democratic side, Chuck Schumer leading the charge. Are these concerns valid?
Well, you know, they have, legitimate concerns about the direction of the court. I mean, the court is, very evenly split on a lot of issues, especially on issues like civil rights and affirmative action and presidential power and abortion rights, voting rights. You know, issue after issue, we have a 5-4 court, and one vote can shift the tide considerably. So, Kavanaugh or any other nominee could change the direction of the country in very significant ways. So, of course, Senator Schumer, as any senator, has, strong concerns about what this nomination could mean. Now, whether he's able to do anything with those concerns is another matter, because it's a political fight, and the question is, does he have the votes?
So let's talk a little bit. In Politico today, they talked about his ascension, again, working within previous administrations, talking about maybe the paper conundrum. There's going to be so much to sift through. We're not even talking legal decisions. We're just talking memorandums and communications. Do you envision this protracting the process?
Well, we'll see. I mean, he does have a great number of judicial opinions. I think he wrote almost 300 opinions while he's been sitting as a judge on the D.C. Circuit. But before that, he was in the Bush White House, where he, in the Office of Legal Counsel, or not the Office of Legal Counsel, the White House Counsel's Office, where he wrote, dozens of memoranda on very hot-button issues, in the Bush administration. And whether we get access to those memoranda, we'll see.
Is there a question that may or may not?
Of course. I mean, that is, the White House will try to resist. They'll say attorney-client privilege. They'll say executive privilege. They'll say you don't need them. We know enough about this nominee. And the question will the Judiciary Committee issue a subpoena for them? I doubt it, because the committee has a majority of Republicans, and they're not going to support that kind of process, because that would slow things down. The more paper that gets out there, the more that the committee has to review, the slower the process will go. So they're going to, I think, resist producing at least the maximum amount of paper. They'll produce some, and then they'll resist on others, and then they'll say, you have enough, it's time for a vote. And whether they can slow it down, that's what Schumer's hoping for, but I'm dubious.
I mean, clearly that's the Democrats' end game, is to slow this up before November elections. If you were a betting guy, do you anticipate that we could see a vote prior to November?
I think we'll see a vote prior to November. In order to slow it down, there'd have to be some sort of bombshell, some sort of significant concern that leads some Republicans, either on the committee or more generally, to say we need to look more carefully at this nominee. I don't see that happening. And when you say the Democrats, long-term plan is delay. Well, that's not a long-term plan. That's like, we get to November and then what?
And then what?
They can't delay for 2 years. I mean, admittedly, the Republicans delayed for a year on the Merrick Garland nomination, but can the Democrats, is there any way that they could delay for 2.5 years? I don't see it happening. So, and I have the feeling that the Democrats will decide that the politics play out against them. That the more they delay, the more it hurts them. It hurts them in the November election. So they'll see that they don't have the votes, get it over with before the November election. But I say that, and I could be wrong, because they're getting pushed by their progressive wing, and for very good reasons. But those reasons may, in the end, hurt them when it comes to the election in November.
So let's talk about how the president comes to this choice and what we've heard in the press. There were reports that I believe the president said he did not ask Judge Kavanaugh about Roe v. Wade.
Well, that may be literally true. That is, he may not have asked him, what do you think about Roe v. Wade? And I assume that if he did ask Kavanaugh, probably wouldn't answer. He's smart enough to not answer, but he doesn't need to ask him that. Kavanaugh has been, a very steady conservative for his whole public career, which goes back quite a long ways. He's a solid Federalist Society member. He worked for Ken Starr. He worked for George Bush. His vote on Roe versus Wade is not going to be that much of a surprise. You don't need to ask him questions, because they know the answer. He's been around long enough. He's not a black box. He's not a mystery candidate. They're not worried about him. One of the reasons why they might have selected him is because they're very confident that he's going to be who he's been for the last 20 years. He's not going to be like Justice Souter, or even in some ways Justice Kennedy, who was unpredictable in certain ways, including on Roe versus Wade.
And so let's talk a little bit again about what we're hearing from the opposition to this nomination as we hear it today. You've seen it out there, all this, should the president be nominating someone while he's under this cloud of legal oversight?
Well, yes. I mean, and there's something to that too. I mean, we're in a kind of unprecedented situation where we have a president who was elected by who lost the popular vote by 2%, almost 3 million votes, and even all of the intelligence committees and all of the intelligence agencies agree that a foreign power worked to get him elected. Whether he participated in that or not is an open question. He's under investigation for cheating in the election. So given the fact that those circumstances, not to mention the fact that the Republicans could be said to have stolen the Supreme Court nomination of Merrick Garland, that at least there was a good point to say, why don't we have a compromise nominee? Why don't we have a nominee that both parties could agree with, a moderate that might have pleased nobody, but at least wouldn't.
Would you have expected a compromise candidate from the Trump administration?
Absolutely not. And to be honest, I wouldn't have expected a compromise candidate if the situation were reversed. If we had a Clinton administration and a Democratic controlled Senate, they're not going to say, oh, it's time to compromise. They're going to say it's time to cash in our chips. That is, they've been wanting a conservative court that will overturn Roe versus Wade and will push back on federal power for a long time. And now this is their chance. To give in now when they're right at the finish line would be crazy from the Republicans' point of view. So I don't see that happening. But as I said, there's a good argument for saying that a president who's elected who lost the popular vote by 2% should not be radically transforming the country because he has no mandate. But that's a political argument. It's not a legal argument. He has all the right under the Constitution to nominate a justice of his choice, and the Senate has the power to confirm him. And so it's just a question really of power, not of right or of constitutional law.
And so let's talk a little bit as well. There was some reports in the media about Brett Kavanaugh's sort of legal insights into the Supreme Court's role over overseeing the president and any criminality.
Yes. Well, it's really interesting. This will be a subject of a lot of the senators' questioning when it comes to confirmation during the hearings. When he worked for Ken Starr in the Whitewater investigation and the Monica Lewinsky investigation, well, he had a very expansive idea of what an impeachable offense was and the power of the independent counsel to investigate the president and to charge him with crimes, or at least to present charges to Congress for impeachment. He had a very broad idea of what an impeachable offense was, lying to the American public. The Starr report, which Kavanaugh is said to have been the lead writer on, they said was an impeachable offense. Well, if that's his view, I think Democrats will be thrilled because, from their point of view, the president is committing impeachable offenses every day. But that was when he was investigating, a Democratic president. But then when he worked in the Bush White House, he wrote an article that said Congress should pass a law protecting the president from investigations and from lawsuits. So, which is the real
does it raise into question, you're the legal scholar here, when he gets questioned here about this, about his consistency in opinions, how much do variations of legal interpretations among during a judge's career really come into play, and do they have to answer that? Well, I answered something this way here, and here is my view here. How much does that come into play?
Well, the nomination process or the confirmation process, the hearings especially, are a work of theater. I mean, the nominees come forward, they tell their life story, someone praises them, and then the senators start asking questions. The friendly senators praise them and ask them very softball questions, and then the hostile senators ask them hostile questions, and the nominee always says, I'm afraid I can't answer that question because these questions might come before me, but I promise I will uphold the Constitution and the rule of law. And they say nothing more, and they don't have to say anything more. What we actually get from the nominees during the hearings is very little about their judicial philosophy. There's no rule that makes them have to answer these questions, and the tradition, at least over the last 30 years, has been they answer the questions as little as they have to in order to get past the committee. So he'll be asked about his views, and he'll say, well, when I was working for Kinsar, I had a role to play. We were investigating under the statute that authorized us to investigate the president, and I took the position that was in favor of my client. Now, when I was a judge, I saw things differently, and we took the cases.
So it was by lieu of the role that he was playing.
Right, and that's what he'll say. He won't have to defend Ken Starr's view of the independent counsel role and what an impeachable offense was. He'll say I was working for a client. So and then when asked what his own view is, he'll probably say, at least when he'll say a little, but when push comes to shove, he'll say, many of these questions might come before me, and I don't want to prejudge them, and it would be inappropriate for me to opine on matters that I might have to decide as a justice. And then he'll smile, and senators will try to ask him again about that, or Roe versus Wade, or anything else, and he'll give the same canned answers. We can't really expect forthcoming, broad answers that are very revealing in the hearings, I'm afraid.
So we heard a little bit from him last night when President Trump made the nomination. One of the things he kept harkening back to is being a strict constitutionalist. When's the last time we've heard from a nominee that they're a loose constitutionalist?
Right. I mean, I'm waiting for the nominee that says, I don't follow the law, I just follow my gut. We haven't had... It's
just sort of a roadmap, I kind of take it as well.
The Constitution and the law is nice advice, and if I choose to follow it, maybe I will, but we'll just have to wait and see. No, they all say that they'll follow the Constitution, that they are dedicated to the rule of law, and you could hear him repeat, and as he did in his first confirmation hearing, what Chief Justice Roberts says is the role of a judge is like a role of the umpire in baseball. They don't make the rules; they just call balls and strikes, which is a very appealing kind of metaphor. That they're not applying their own ideas; they're just calling balls and strikes. But that metaphor is so far from what justices on the Supreme Court actually do that it's impossible to make sense of that.
I mean, because when they have opinions, that's what happens. There's a decision, and they issue an opinion.
Right. It's not like a ball and a strike where they're at least they're. I mean, you actually have pretty wide variation about what a ball and a strike is in baseball too. But at least there's a basic rule.
Here is the box.
Between the knees and the shoulders, over the plate. But there's some variations. About what it is in baseball. But with the Constitution and with law, there's no box. You have very broad language in the Constitution, like equal protection for all or free speech. But what those words mean is up to the justices. That is, what does equality mean? Well, they get to decide. Is it treating people unequally if two people of the same sex can't get married? Well, 4 justices thought that it was perfectly constitutional to tell two men or 2 women that they couldn't get married. That didn't violate the Constitution. 5 justices thought that it did. They thought they were being treated unequally. So that is, it's not balls and strikes, people. It's it's judgment. And where they get their judgment to decide what equality means or what free speech means, that comes from, a variety of sources and from who they are. There's no taking out the subjectivity from the role of the U.S. Supreme Court. They could pretend that they do, originalists.
And that's what they're going to say, especially during this part in the
Oh,
process.
yeah, it's not my view. The Constitution made me do it. That's Justice Black was a textualist. He used to carry around a pocket Constitution with him. And when people said, why did you decide such and such case? Or why did you rule this way? He would take out his pocket Constitution. He'd say, I didn't decide that case. It wasn't me that did it. The Constitution made me do it. But the truth is that there's just a lot of room for interpretation in what the Constitution means. And where they come from, and what their philosophy is makes a great deal of difference in terms of what their decisions are, and therefore what rights we have, what powers the government has. I mean, huge questions of everyday life will be decided based on what is in Brett Kavanaugh's heart. But we're unlikely to find out much about that in the hearings.
In the hearing process, that's for sure. How exciting of a time is it to be in academia and to have students and to be going through this right now from a Roger Williams University Law School lens?
Well, it's actually a lot of fun. I taught a course on the Supreme Court. Well, I teach a course on the Supreme Court every year. So every year we go to the court and we watch arguments, and the students are really excited about it. They, we sometimes meet with the justices. 2 years ago when Merrick Garland was nominated, we had a whole session about the nomination process. The students get really jazzed up about this stuff, and rightly so, because the decisions of the court are going to be the tools that they use in their working lives. So I love working with students to lead them through the confirmation process and talk to them about the role of the court. I teach a year-long constitutional law course, and students are fighting all the time, and this is and I love it. As long as they're not throwing chairs, and happily our chairs are bolted to the ground, so I don't have to deal with that often. But
does it get heated?
It does. When it does, I'm excited. Like when I can sit back and the students are saying, I think Scalia is right, or I think Ginsburg is right, and they're making real arguments, the way lawyers make arguments, not just, the way pundits do. Then I get real excited, and then I feel like, my job is done when they can argue without me.
Well, there'll be plenty to talk about at Roger Williams University Law about the nomination of Brett Kavanaugh. And Jared Goldstein, I appreciate your coming back again today to talk with us.
Oh, it's no problem. I was happy to talk to your
I'll let you
watchers.
go right around the corner. Actually, we'll both go around the corner, and we'll be right back here in the Navigant Credit Union Broadcast Center. Okay.